to ensure the integrity of the judicial process. That single sentence just sealed the loudest child abuse case in America. It was written down on paper, signed by a judge in a small Ohio courthouse. 12 words that most people scrolled right past this weekend. But if you read them carefully, you can hear a door closing on the entire Siders case. And you need to know what is behind that door before it locks all the way shut. I want to talk to you today like a neighbor talking over the fence, not like the news, not like a lawyer, just plain talk. Because what happened between Thursday night and Sunday morning in Vinton County, Ohio, most people missed it. And it matters. It matters more than the raid. It matters more than the hearings you have already heard about, because this is the piece that decides what you will and will not be allowed to see from here on out. So let me walk you through it slow. Take a breath with me. On July 23rd, a judge named Fetherolf Rogers signed a second gag order. The first one from July 14th was already strict, but this one is different. This one is bigger. This one has teeth. And this weekend, the full written reasoning behind it finally reached the public. That is why we are talking about it right now, and not 2 weeks ago. Let me explain what a gag order really does. A gag order is a court paper that tells certain people they are not allowed to talk about a case, not to reporters, not to the public, not on social media, not at the coffee shop, nowhere. Now, most gag orders are short. They say something like, the lawyers may not speak to the press. That is it. Broad, bare, simple. The July 14th order was that kind, broad and bare. But the July 23rd order is a different animal. Listen to this next part carefully, because this is where it gets serious. The July 23rd order names 5 different groups of people who are now silenced. Not just the lawyers, but also their staff, their investigators, their expert witnesses, and a phrase that shows up in the paper called agents or representatives. That last phrase, agents or representatives, that is the one that does the heavy lifting, because it means anyone working for the defense in any form, in any way, cannot speak. A paralegal, a private investigator, a friend hired to review paperwork, all silenced. And it is not just who cannot speak, it is what they cannot speak about. The July 23rd order names 4 topics that are now off limits: the merits of the case, the evidence, the discovery, and any personal opinions about the character of the people involved. You see what happened there? The judge did not just say, be quiet. She wrote out a map of every direction quiet had to go. That is why lawyers I trust have been calling this order surgical. It is not a swat, it is a scalpel. Now here is where I want you to slow down and think with me, because there is a question underneath all of this that no one on the news is asking out loud. Silence protects someone. It always does. Silence in a courtroom is never neutral. So the real question is, who is this silence protecting? Is it protecting the defendants? Yes, in part. A person accused of a crime has a right to a fair trial. And a fair trial needs a jury pool that has not been poisoned by news coverage. So one answer is, this silence protects the accused. Is it protecting the future jury? Yes, also in part. Because when 12 people from Vinton County finally sit down in that courtroom, the judge wants them walking in with clean minds, not minds already filled with headlines. But here is the harder question, the one I want you to sit with. Is this silence also protecting the truth from being told too early, or is it protecting some people from ever having to answer for what they said and did? That is the beat you have to feel to understand this case. Because the same sentence, to ensure the integrity of the judicial process, can mean 2 very different things depending on who reads it. If you are a defense lawyer, that sentence is a shield. If you are a reporter, that sentence is a wall. If you are one of the 16 children who came out of that house, that sentence is something else entirely. It is a promise that someday in a courtroom, a jury will hear the whole story, not the version leaked to a newspaper, the whole story. And that is why judges write these orders, even the tough ones, even the ones that make journalists furious. But, and this is important, this order has a hole in it, a real hole. And I want to make sure you see it, because most people did not. Here is the loophole. The July 23rd order silences the people who are working on the case. The lawyers, their staff, their agents, their representatives. But it does not silence the family. Read that again with me. It does not silence the family members who are not defendants. The Siders family is a large family. There are cousins, there are in-laws, there are neighbors who saw things. There are relatives who lived in that house at one time or another, and none of those people are lawyers. None of them are staff. None of them are agents. So none of them are covered by the July 23rd gag order. which means the news you hear from here on out, if there is any news at all, will not come from the courthouse. It will come from the kitchen table, from a cousin, from an uncle, from someone who was not paid to keep quiet. Now, is that a good thing or a bad thing? That is where your own head has to weigh in, because information that comes from family members is not always reliable. It can be exaggerated, it can be settled scores, it can be old grudges wearing a new coat, but it is also sometimes the only truth left when every other door has been shut. I want to be honest with you about something else. There is a reason the news went quiet this weekend. And it is not because reporters got lazy. It is because a lot of them just read the July 23rd order and realized that most of their usual sources, lawyers, staff, spokespeople, are now off the table. So watch the coverage change over the next 2 weeks. It will get slower, it will get quieter, it will start relying more on paperwork and less on people. That is what a good gag order does. It changes the shape of the story before the story even gets to trial. Now let me tell you what I keep thinking about when I read this order. I keep thinking about the phrase integrity of the judicial process. Integrity. That is a big word. It means wholeness. It means something that has not been broken into pieces. And in a courtroom, integrity means the case reaches the jury in one piece, without leaks, without spin, without a single juror walking in having already made up their mind. That is what the judge is protecting. But integrity cuts both ways, because the same word integrity also means honesty. It means telling the truth even when it is uncomfortable. And there is a version of this case, the honest version, that a lot of people have not heard yet. And the July 23rd order makes sure they will not hear it. Not yet. Not until the trial. So the question I want to leave you with is this. Is silence the same thing as safety? Because sometimes it is, and sometimes it is not. Sometimes silence in a courtroom means a fair trial for everyone. And sometimes silence means the loudest people win because they were the last ones allowed to speak before the door closed. I do not know which one this is yet. Neither do you. Neither does anyone. That is what makes this weekend different. That is what makes the July 23rd order different from the July 14th one. Because this order, this surgical, named sharpened order, closes the courtroom mouth for real. And now we have to wait for the grand jury, wait for the indictment, wait for the trial itself. And in the meantime, we watch the paperwork, we read the docket, we pay attention to what is filed, not what is said, because that is where the story lives now. I want to point out one more thing that most people missed. The judge did not sign this order by accident. She did not draft it in 10 minutes. This kind of written reasoning with named categories and named topics takes hours of thought, maybe days, which tells me she saw something coming. She saw a wave of media attention building, and she chose to get ahead of it. That is a judge who has been through this before. That is a judge who has watched other cases fall apart because someone talked too much on television. And that is a judge who decided, not this one, not on my watch. That is worth something. Even if you disagree with the order, even if you are a reporter frustrated by it, that level of care from a small county judge is worth noticing. Now let me talk to you for a minute about how this affects you as a viewer. If you have been following this case, you probably have questions. You want to know what the children saw. You want to know what they said. You want to know who is going to prison and for how long. You want to know if there was more than one adult in that house doing wrong. I want to give you those answers. I really do. But I cannot make them up. And now, because of the July 23rd order, the people who could give me those answers are not allowed to talk. So I will not have them for you until the case moves forward. What I can promise you is this. I will read every piece of paper that comes out of that courthouse. I will read every motion, every filing, every docket entry. And when there is something new to tell you, I will tell you. But I will not guess. I will not repeat rumors. I will not fill the silence with noise, because that is exactly what the July 23rd order is trying to prevent. Before I let you go, I want you to notice one more thing. The July 23rd order applies to Christina Siders specifically. It was filed on her behalf, meaning she asked for it, or her lawyers did on her behalf. That is a choice. That is a strategic choice. And strategic choices in criminal defense always tell you something about the person making them. A defendant who wants silence is a defendant who is worried about what the noise might do to them. That is not a legal statement. That is a human one. Anyone who has ever been accused of anything, even something small, understands it. You want the noise to stop. You want the case to be about what is in the file, not what is on the news. So when you hear about a gag order in the Siders case, I want you to remember, it was requested, it was written, it was signed. And now it is the law of that courtroom until further notice. And the louder a case gets, the harder judges work to make it quiet. Ask why. That is your homework. Ask why. If you have made it this far, thank you for staying with me. Thank you for caring about the details. Thank you for not scrolling past the paperwork. Because in cases like this one, the paperwork is where the truth ends up living for a long, long time before it comes out into the sunlight. Share this with one person you know who has been following the case. Not to spread rumors, not to guess, just to keep somebody informed about what actually happened this weekend in a small Ohio courthouse. Because 16 children came out of that house alive. And the least we can do while the lawyers argue and the judges write is stay awake, stay informed, stay curious. The louder it gets, the harder they will work to make it quiet. Ask why. Every single time. Ask why. I will see you in the next one. Take care of yourself. Take care of the people close to you. And if you know a child who does not feel safe, say something. Do not wait. Do not assume someone else will. Just say something. Because that is how 16 children in Ohio got out. Somebody somewhere finally said something. And that is where every real story begins. Let me leave you with one small thing that has been sitting in the back of my head all weekend. When a judge in a small town writes a careful order like this one, she is not thinking about clicks. She's not thinking about ratings. She is thinking about the 12 people she has never met yet, the ones who will one day walk into her courtroom and hold the future of 6 adults and 16 children in their hands. That is who Judge Fetherolf Rogers was writing for on July 23rd. Not for us, not for the news, for those 12 strangers. And I think that is worth respecting, even when it makes our job harder as viewers. Because the point of a courtroom is not to satisfy the crowd outside. The point is to reach a verdict the crowd can live with 20 years from now, 40 years from now, when those 16 children are grown and looking back and asking, did the system get it right for me? The July 23rd order is one small step toward being able to say yes, or at least being able to say we tried. That is what I want you to hold on to as this case goes quiet.